All right, so our first panel is called Doctrine and Dobbs. What did Dobbs do? And we have three speakers on this panel. First, we have May, exactly, who is a professor of law at Michigan State University College of Law. Our second speaker is Jessie Hill, who you already met. She is our very own Associate Dean for Research and Faculty Development and the Judge Ben C. Green Professor of Law at our law school. And finally, we have Mark Spindelman, the Isidore and Ida Topper Professor of Law at the Ohio State University College of Law. So without further ado, May.
Okay, thank you very much. You said earlier we had very distinguished speakers, but I'm here too. So here we go. My title is How Radical is Dobbs. And as I thought that through, I tried to figure out, should I go through doctrine and inch my way through doctrine, try to figure out factors to compare it to past work of the Supreme Court. I think that's probably not the best way to try to inch through it, because that's sort of like, doesn't address radical well enough. So then the other way to think about how radical is Dobbs is the voice of the people. So I've been spending some time interviewing the people, like on airplanes and here. So we'll get to that in a bit. So in terms of the, as I ran around using the word radical, it began to hit me. I'm using the word radical. And then I noticed that Jessie had said to me in an early thing, you might want to define radical. So I began working on that. And I noticed that in some ways radical is not considered a bad thing. We need radical reform people frequently talk about. And the good lefty activists over the years, lawyers, there's a radical component of the left. We don't, I don't know who we is. The we that I've had some part of has thought that's okay up to a point if you don't like punch the judge in the face or something like that. So, but it does seem that there's a view that radical can be used in a way that's not exactly right, meaning extreme, bad, awful. So I suppose that's what I've been asking when I say how radical is Dobbs. And I found something that talked about people misuse radical as though it's something bad. And that was from the left angle saying, don't do that when we talk about radical activism. So, but I'm going to go to the voice of the people, all of whom seem to think it's, when I say how radical is Dobbs, they think I'm asking how nuts is Dobbs, how out of line, how crazy, how awful. Because apparently somehow when you fly on airplanes and you talk to people around here, nobody says, well, it's fabulous radical reform. Nobody has said that to me yet. So some of the voice of the people, well, I guess I would mention how I try to do a little doctrinal stuff of a sort institutionally to say in the history of the Supreme Court, what cases might we call radical? And so obvious things you think about are Dred Scott and Plessy v. Ferguson. Some people mentioned Lockwood. But when I asked some colleagues, one of them said Roe v. Wade. And I took it that was not good radical, but I didn't pursue the question. So anyway, it seems like there is some similarity between Dobbs and both Plessy and Dred Scott, because both of them have some quality of erasing a part of the population. Now, perhaps that's a radical way of saying what Dobbs does, but on the matter of is a fetus a life, I looked around to see, okay, so there are arguments that are sound in what is considered to be morality. And so they sound in the idea that a fetus is a life, therefore women cannot, or a pregnant person cannot have full autonomy because there's a competing life with the notion. So far as I can tell from Dobbs, and I admit I've not studied it really deeply because I didn't have to teach this year. And I don't but apparently, so far as I know, nothing in Dobbs says anything about the life of a person who's pregnant as and a balancing of that life. So I double checked, and it turns out a lot of places do say, okay, a fetus is a potential life, However, according to what I found, in a, I think it was on a medical, it was on a medical thing. And it was a doctor saying the notion that a fetus is alive, and therefore if you have an abortion, that's a killing. That's simplistic. If you then go to the idea it's murder, it's homicide, it's unjustified homicide, and the point would be that no, that killing a human being is not the last word on is there a murder. There's a lot more you got to go through to figure out how come this human being got killed. And so other nations that have the notion there's fetal life and that it's got to be taken into account always say that a pregnant person has to be taken into account, and that any interest in fetal life or personhood cannot override women's fundamental rights. And in South Africa, the phrase is proper regard must be had to the rights of women as enshrined in the Constitution, including women's rights to life, privacy, health, equality, freedom and security of the person, including reproductive and bodily autonomy, respect for human dignity, and freedom of religion, belief, and opinion. Well, there's a lot there, isn't there? Now, Mark might not want to comment on it, but I sort of whispered to him, like, is there anything to give a clinician help in Dobbs if they're trying to argue against nutty legislation? And he said, yeah, there probably is. He may not have time to talk about it, but you might want to look around and see if there's anything. As far as I can tell, there's nothing that talks about women and having any of these nice things that other countries talk about, fundamental dignity, fundamental rights of women. So that seems pretty radical. And so that way, I think it shares characteristics with Dred Scott and Plessy, in that it erases a part of the population in some respects. And it sort of like puts women into a pre-modern classification. They've gotten out of that. And so when this first happened and people were saying to me, oh, this isn't bad, well, women are going to have, I know it's not going to work. The culture has moved. It's impossible. Women are equal, fully participating citizens. It can't happen. It just won't work. You can't impose this on culture. But since then, a lot of stuff's been going on in legislatures that I can be honest, in Texas, we have somebody here I spoke to, big litigation Texas, about the part, I don't know which one you've done, but like if somebody tells a woman, hey, go get a cab over there, they're subjected to massive civil liability. That's the deal where, I don't know, maybe I'm assuming too much knowledge, but the thing was passed, and the idea was it's not reviewable because the way they did it, there's no state action. Anybody, I think maybe perhaps anywhere, could sue anybody in Texas, you can correct me if I'm just approaching that, for helping a woman have an abortion. And the civil liability is massive, it's draconian. So I guess maybe my title should be how draconian is Dobbs. So there's a lot going on that strips women of all kinds of rights. These rights across the board, they're attacking freedom of speech, that's freedom of association in Texas. So the whole array of fundamental rights are in play, and who knows where it goes, because the court said, well, this is just about abortion, and well, how can it be just about abortion if they distort freedom of association, standing, freedom of speech? Because they're trying to say websites cannot, because now it's a crime in a lot of places. So you can't, there's some limit to free speech if you're telling people how to commit a crime. That's never been fully figured out. Like, can you tell people how to do a hydrogen bomb? Turns out, well, everybody already knows. So it's not a problem. All right, so I want to go to the voice of people a little bit and my efforts to find out what people think. As I say, it turns out I never talked to the people who are the people who are the voice of Dobbs. And so the voice of Dobbs is, as I understand it, a conglomeration of a lot of the voice of a movement of some people, but a minority. And so I've been, however it works, incidentally only talking to people who are not part of the voice of the people inside the opinion. But it does seem to me like the opinion in some respects less legal doctrine than it is the voice of people imported into an opinion of the U.S. Supreme Court, when we all worship and adore. And I wish I were on the court and I got a mortgage and I would like travel. Pay it off. Yeah. So let's look at the voices of the various people. They're politicians. And so this has something to do with law because it has something to do with respect for the law, right? So what did anybody know what Senator Fetterman said in a release on the case in which I consider to be the legitimate child of Dobbs, i.e. it's called, I looked it up, Hippocratic medicine, the FDA. What did Senator Fetterman say in a release once he got out of the hospital? He said, this ruling by a hard right Trump, I mean, it's an official release. This ruling by a hard right Trump appointed judge is simply bullshit. So that's what one voice of the people says. A U.S. Senator from Pennsylvania said that. Marjorie Taylor Greene, do you want to know what she said? All right. It's a bit of a miracle. Unless miracles are all, well, what does radical mean and what does miracle mean? Are miracles all just good? I don't know. I can tell on that. All right, then the Republican representative from pretty much Charleston, I think, the South Carolina Republican representative, Nancy Mace, what did she say? She said, oh, this is again the stepchild, no, the legitimate child. She's talking about the FDA stuff. She said, this is an FDA approved drug. I support the usage of FDA approved drugs, even if we might disagree. It's not up to us as legislatures to decide, or even as a court system. I agree with ignoring it at this point. So a representative from South Carolina joined the crowd that said just ignore it. She agreed with Alexandria Ocasio-Cortez that they should say, but nobody has explained how you go about ignoring federal injunction, or the Supreme Court enters the picture and says, yeah, the FDA doesn't know how to do science, and we do. And by the way, the methodology in that it's not really about abortion, although Matthew did start out by saying, I'm not going to talk about the fetus, because we're talking about unborn human. And so that's what this is about. But then he said, the FDA doesn't really know how to do science, and I do. So that's kind of, and the administrative procedure is correct, he said. Now, let's go to some law professors. So I like who are talking on blogs, not in law review articles. Garrett Epps, I like him a lot. And he has one thing in the Washington Monthly called the court's third great crisis, comparing what the court that they've done to Dred Scott, where they're trying to return to an imaginary past. So in Dred Scott, the imaginary past was complete total dominance by white males. Now, of course, you got Clarence Thomas on the court, and he's kind of doing Dred Scott for the 21st century. I don't know how to figure it out. But, there is a lot of rhetoric about this is white males doing this stuff. And in the legislatures, it pretty much is. Although there was a black representative yesterday, everybody said something pretty crazy about his view. And, death penalty for people who have an abortion because of pro-life. So, that was pretty now, so he talks about a successful annexing Garrett Epps does of the federal judiciary to the political party system. He summarizes it as a combination of the GOP, conservative legal movement, and billionaire backers. He said that before we knew about Harlan, and the politicized wing of white evangelicals. On Dobbs, he says it has, and this is something that's been was initiated by my 5 minutes or not.
Yeah.
All right. So Kennedy started when he said in the partial abortion case that women don't, because they're pretty little heads, they don't quite understand what abortion is. And so we got to educate them by forbidding something, which I kind of never heard of, like we try to educate their choice by not letting them do something. And by telling them you can't do it, they do horrible things to the unborn human. Then they will realize, and if they were to have an abortion, they would regret it for the rest of their life. So I think we have, he talks about a feigned concern for women, like let's let little babies have their babies, will help them out somewhat, because they all want to have babies, they just think it's might not think that I have enough money or something like that. Now, I've met a lot of women who my understanding is that's not what they're thinking, but who knows? Now, so it's concerned, he says, it isn't law, it is theology. So that was my question, why parse Dobbs? Because it doesn't seem much like law. It seems like a fantasy imposed on, and it's a fantasy construction of what a pregnant person is. And of course, pregnant people still are mostly women. I like to make sure I don't fail to note there are other people who as an individual could have a bad impact. But as a population, the impact on women is across the board, because how can you say you still are just a regular old citizen when there's this special body of law that is now metastasizing into, well, be careful about traveling across state lines. You wrote about that in your paper some time ago about the could be possible to really do that to people. She does doctrine way better than I do. Once I hear the doctrine and it sounds absurd, that's kind of like all I want to hear. But you can parse it more than that. At any rate, I also wanted to say, and because we're running out of time, oh, I haven't said the thing that the issue on the airplane. I asked somebody named Jermaine sitting next to me, how radical is Dobbs? He used to be a Marine. And he said, it's fucking radical. So I've been asking people, did I say that word? I didn't say it, Jermaine said it. The next thing is, I asked somebody at the Glidden House, who is from Abingdon, Virginia, and came for symphony here, how radical is, so she's from Abingdon, Virginia. I thought, okay, I could get in trouble. I said, how radical is Dobbs? She said, it's prehistoric. So there's some voice of the people. Now, Biden doesn't like to say it a lot, but he's just a new rule to protect women crossing state lines for abortions. Maybe all know, is it, who is it? Is it Idaho that said it's criminal to help a minor cross out of Idaho to get an abortion? I guess it didn't criminalize the minor. But the other thing that's radical about it, by the way, is it wipes out massively pretty good reasoning. Like Casey had a very good essay, I guess it was Casey, or one of them, why minors have constitutional rights. And they said, well, maybe they shouldn't do it on their own. They're not mature, so but you got to have judicial bypass. And so there's really good writing and a lot of the body of jurisprudence about coming from Rose and Casey. It's kind of wise. There's actually some wisdom, even coming from people like Sandra Day O'Connor. I won't say there's no wisdom there whatsoever. She also explained in rather great detail the extreme danger to a woman who's pregnant in a marriage that's not a healthy marriage. Alito dissented and said, no, the man will help her. He will tell her, honey, we have the money, don't worry. Okay, 5 minutes, you sure I have that much? Or is it all over?
Okay, I'll reduce it to 3 now.
Let's see if I have any other good. Well, so some people say, look, the bad news is the decision is pure chaos. That's the Fifth Circuit appellate review of the you can't use my papers. So it sort of gave a little bit of an opening that it's not an injunction against the FDA, but the Comstock Act is still there. So apparently the bad news is pure chaos. It imposes restrictions that no court has the authority to impose. It wrongly claims the judiciary has the power to override the FDA scientific judgments. So that's the metastasizing stuff. And nobody's sure what the Supreme Court would do, even though this stuff's kind of nutty. And the standing in that one is, they gave standing to some doctors who said, I'm worried that if the pill doesn't work right and somebody comes to an emergency room, it'll make me feel bad. That was standing. That was the concrete injury to some unknown doctors. So I guess my last thing to say is, Years ago, I came across something Sandy Levinson wrote that said, you know, is a law school a school of theology or is it a school of religious studies? So in some respects, you got to figure out if you're a practicing lawyer and they're in front of a judge, are we doing theology? And we sort of are. It seems to me like, and I need to ask a Catholic, what do you call it when the Vatican gets together? What was it John Paul did, where they promulgated a whole new canon law? What? Yeah, so in other words, Dobbs is sort of like Vatican II. So if we see being a lawyer as being part of being a theologian, if you're in court arguing, then you got to like start doing your theology moves. Or do you just go all radical on them and say this is bullshit? Now, my guess is that didn't work well in court, but I didn't ever do that kind of thing, so who knows?
Thank you. So I am going to be presenting a paper. I actually am sort of pinch hitting for a colleague who wanted to be here and had a family emergency and was not able to be here. So I'm presenting a paper that I presented at a symposium on the future of reproductive rights. And my paper is sort of a defense of Roe v. Wade. So you might first ask, well, why would you present a paper about Roe v. Wade at a symposium on the future of reproductive rights? Because it seems like nothing could be more in the past at this point than Roe. But I think it has a lot to do with the future of reproductive rights. And so I'm going to explain for a minute why, and then I'll get onto my defense of Roe. So right now we are in sort of in the wake of the overturning of Roe, we're seeing a new round of litigation in state courts of advocates trying to protect reproductive rights, mostly under state constitutions. And so these advocates, many who are arguing for the first time that their state constitutions protect a right to abortion, are having to decide, you know, what do we argue for? What does that right look like? How does that, you know, what we're kind of starting from a blank slate, right? So we can kind of argue for any kind of right we want. Turns out that right so far is looking a lot like Roe v. Wade. And the cases are really coming down, and where they are finding rights that look like Roe v. Wade. And specifically, the idea that this right is protected by a principle of reproductive autonomy, privacy, decision-making autonomy, and also that it's protected by strict scrutiny as a matter of constitutional law. So I guess the reason why I want to go back to Roe itself then is to say, well, you know, if Roe was really a terrible decision, as first of all, Justice Alito certainly thinks it was, but a lot of people have said over the decades that it was, then we probably shouldn't be replicating it, right? We shouldn't be doing Roe 2.0. So let's go back and take a minute and look at Roe. So, so the sort of badness of Roe is certainly kind of the received wisdom, and that is true arguably across the legal academy. So people who support abortion rights, people who don't like abortion rights have argued that Roe, whatever you think of abortion, Roe was a terribly reasoned decision. And there were a lot of prominent critiques from folks like Lawrence Tribe, so liberal constitutional scholars, Lawrence Tribe, John Hart Ely, Akil Amar, Archibald Cox, Mark Tushnet, Philip Bobbitt. You might notice that none of these folks, I think that there's not like a uterus among them, but they all had issues with Roe, and one particularly brutal takedown of Roe, really widely read critique of Roe, is John Hart Ely's essay, "The Wages of Crying Wolf," and that's where my title comes from, Big Bad Roe. So his most famous line maybe was that Roe was not constitutional law and gave almost no sense of an obligation to try to be. And kind of interesting that A was just talking about how Dobbs is really not law and not constitutional law, because I think that's the kind of comparison I want to set up here. And actually, Ely's criticism of Roe in that essay makes a really prominent appearance in the Dobbs decision. You know, Alito kind of gleefully embraces this critique as a way of saying, surely, you know, even liberals thought Roe was a terrible decision. This really gives ammunition to the overruling of Roe. and it's a longish article. I mean, it's a full length article. I'm not gonna be able to barely summarize it fully here, but I'll just say that the thrust of Ely's critique is that, first of all, the abortion right is not grounded in precedent. Second, that the court never justifies the weighing of the two interests involved. So those of the pregnant person and those of the fetus. He basically says that this is Lochner all over again, and that there's no coherent grounding of the right. So just to sort of briefly respond to that criticism, and there's a lot to say about this article. If you go back and reread it, actually, which I obviously did, there's some really shocking language in this article. And this is not even the worst of it, but often he refers to abortion bans as basically restricting women from living their preferred lifestyle, that it cramps their lifestyle to have to carry an unwanted pregnancy to term, and so on. So, but I think even more importantly, to say that there was no grounding in precedent, even in 1973, I mean, I think you really have to ignore Meyer, Pierce, Meyer v. Nebraska, Pierce v. Society of Sisters, Skinner versus Oklahoma, right, which recognized the right to procreate as a fundamental right, Griswold, of course, and Eisenstadt v. Baird, perhaps most importantly. And then today, to go back and say that Roe had no grounding in principle or in precedent, also you have to ignore, Cruzan and Obergefell, right to die, same-sex marriage. It is incredibly, as a matter of fact, arguably more rather than less grounded in precedent, because it does than some of those other cases, because it does find itself at the intersection of both a right to bodily autonomy, which is older, which is, you find cases back in the 19th century, and the right to, fundamentally make your own decisions about fundamental personal matters like whether to bear or beget a child. But also, there's he criticizes Roe partly coming from his own perspective on constitutional law and judicial review and what the point of judicial review is, and his view famously is basically that judicial review should reinforce rather than obstruct democratic decision making, unless there's some sort of defect in the democratic process that causes the need for courts to step in. And he's so, for example, if legislation disfavors a discrete and insular minority who cannot exercise political power, it's the role of the courts to step in. Ely then proceeds to explain that if anything, fetuses, not women, are a discrete and insular minority. And then he supports this by pointing out that while women are underrepresented on state legislatures, there are no fetuses on state legislatures. Right? Law professors, like, what would you do if a student wrote that in a common law exam, right? So I think that, while it's funny and to me, and I think, it's strange. I think that the point about this critique is that he basically repeatedly, and he does this throughout the article, engages in the same thing that he accuses the court of doing, which is assigning moral weight to the fetus without explaining, and assuming without explaining that the fetus is a person that has interests that are at least equal to, if not more weighty than, the pregnant person's interests. He says that the court, assumes the opposite, but he is clearly assuming that there's no way you could write a line like that unless you were assuming fetuses were at least moral entities that carry interests that the state has to protect, and that they are at least arguably equivalent to those of living people. Okay, so that was sort of a very quick rebuttal of Ely. I just want to spend the next part of my remarks asking, was Roe constitutional law? Was it a good decision? Again, I struggle to see what is so problematic about Roe from this perspective. So how do we decide whether something is constitutional law? I mean, that you could probably talk like all day about that alone, but one thing we could say about constitutional law, we could look to Philip Bobbitt and other people have done this too, but have kind of pulled out what Philip Bobbitt calls modalities of reasoning in constitutional law, he says, courts generally employ one of these 6 modalities of reasoning: structural, textual, ethical, prudential, historical, and doctrine. And other people have kind of said basically the same 6, maybe there's 4, maybe there's 5, right? But again, Roe draws on most, if not all, of these modalities. So as I just noted, it reasons from precedent and doctrine. It drew on Griswold, it drew on Eisenstadt, which very explicitly laid the groundwork for Roe in saying, if the right to privacy means anything, it is the right of the individual, married or single, to be free from government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. I think that we could see Griswold, which also Roe relied on, as being in many ways a textual decision. It reads the right to privacy from the textual guarantees in the Constitution. At a minimum, it is a structural argument about what the structure of the Constitution leaves to individuals, what kinds of decisions it leaves to individuals. And as I noted, I think given that it's at this intersection of 2 lines of precedent around bodily autonomy and individual personal decision making, I think it's even more strongly grounded in precedent than the cases that came before and came after. Also, a lot of folks criticize Roe's sort of wide-ranging and some claim cherry-picked survey of history over literally centuries. I mean, I think that's first of all, I think we could understand that historical journey as being what Bobbitt refers to as ethical reasoning, because it's an attempt to find what he calls the ethos of American and Western culture, and kind of what have attitudes been over time and how have they changed. But I really think that any criticism of sort of Roe's venture into history is pretty rich, coming from the author of Dobbs, right? Back to 13th century historical the British common law, right, to see what Alito thought the attitudes towards abortion was. And so a huge chunk of the opinion, right, is just this sort of freewheeling historical discussion. Okay, and then also I think if we wanted to, so we can see how Roe used fairly conventional modalities of argument, well known to constitutional scholars. I think the other thing that constitutional law does is it uses tests. It uses tests to answer questions, and it uses levels of scrutiny. I think we can ask whether Casey kind of went off the rails on this with the undue burden test. Maybe it did, maybe it didn't, but certainly strict scrutiny, which is what Roe said protects the fundamental right to end pregnancy, is a fairly conventional, is a very well-known test in constitutional law. And again, while we can criticize, and people have criticized the trimester framework as being excessively wooden, maybe a little like too neat, right? In essence, all it was an application of strict scrutiny and an attempt to give guidance to lower courts by saying, this is the point at which the state's interest in the patient's health becomes compelling. And so health restrictions can be imposed. Here is the point at which the state's interest in potential life becomes compelling. And so abortion can be banned, except to protect the life and health of the patient. I mean, again, that framework did end up getting a little bit loosened up in later decisions. It certainly needed some adaptation, but the basic idea that you apply strict scrutiny, you identify state interests, you identify whether they are compelling enough to overcome the interest on the other side in the particular restriction that you're reviewing. I mean, that's how constitutional law works. So again, I really struggle to see how it is not constitutional law or trying to be. And then what about this viability line? Again, I mean, certainly there have been criticisms of the idea that viability is a sensible line to draw, after which abortion can be banned. And of course, in 1973, the point of viability kind of lined up with the start of the third trimester, so it helped create this trimester framework. But I think the thing about viability is that it certainly has a certain intuitive moral force as a line to be drawn. It's the point at which the ending the pregnancy does not necessarily entail the destruction of the fetus, right? In order to vindicate the person's bodily autonomy. I mean, it's certainly difficult. There's no obvious other more easily justified line that I have seen proposed for a point at which the interest in potential life becomes compelling. Maybe there's no point, but if there is, I think that the point is that the difficulty of line drawing too is endemic in constitutional law. We see it in all kinds of doctrinal areas, and generally courts don't throw up their hands and say, it's too difficult to tell the difference between protected and unprotected speech, or between speech and conduct, so let's throw the First Amendment out, rational basis. Right. So, okay, and then finally, how does Dobbs again compare on this point? Well, Dobbs purported to draw a very bright line that would be much clearer and more administrable, and would finally get the federal courts out of the business once and for all of deciding abortion cases. So how has that worked out? So far, well, as I mentioned earlier, we are waiting at this very moment to see, less than a year after Dobbs, whether the Supreme Court is going to step in again in this Mifepristone case out of Texas. There have been myriad other cases, not just in the state courts, but in the federal courts around, for example, EMTALA and its interaction with abortion restrictions. There's right to travel issues that May was referencing. Okay, so I think between the two, it's certainly not at all clear to me that Dobbs holds up any better as an example of constitutional law. So all of this is basically to say that I very much disagree that Roe was somehow an unusually weak or ungrounded opinion. I think that's just sort of received wisdom that has gotten repeated without really much examination, and it certainly is not a bad decision as compared to Dobbs itself. And again, I do want to end with another point that I hit on before, which is that, this is not to say that Roe is enough, or Roe is ideal, or Roe is a perfect place to end up. But I certainly don't think it's deserving of the criticism that it's.
So let me just start with a couple of things to the deans, to Verona, to.
So it's all up to you guys in the room, and I look forward to hearing your questions. Maya.
Thank you all so much.
I have a microphone over here. I'll be right for you.
We are recording this program.
Yeah, that's not.
Well, thank you all so much. It's just so wonderful to hear from all of you. Jesse, my question is for you. I love this, defense of Roe, and I understand you're still keeping the reproductive justice criticisms of it in mind, but defense as constitutional law, especially because, as you said, going to state courts and state constitutions now, we need to have something, right? We need to have some basis. And that also made me think about the received wisdom criticizing Griswold, right? Because, contraception is coming next, because Merrick also has the opinion where he said that parents' fundamental right to control their kids means that adolescents cannot access contraception in Texas at Title X clinics anymore. And, I feel like the received wisdom of Griswold was also very critical of the textual, of sort of the penumbras and the emanations. And there's this received wisdom, I've always taught it in constitutional law as, the criticism that he went skipping through the Constitution saying, give me a P, give me an R, privacy, and it sort of ridiculed that method. And I wonder what you think about that coming back as a method and defending that method as well, whether it's for contraception or abortion or LGBT rights. And what are the methods that we are going to argue for to counter this push of originalism, this because I find my students asking that too. Well, if it's not originalism, what is the method?
Wow, that's a wonderful question, and actually, I think Mark might also have some thoughts about that, but I think, because we've kind of had conversations about this, about Griswold in particular, and I think, so, yeah, Griswold, that's so interesting, like, I think Griswold, I kind of alluded to this in my remarks, is in some ways a textual decision, right? At least it looks for textual hooks, and it also, like, it says that we have all these, I see it as really like what the court refers to as structural argument about the Constitution. It says, we have all these provisions in the Constitution, and granted, none of them explicitly says right to privacy, right to have certain decisions like, kept out of the government's hands. But, we can kind of infer that from the way the Constitution structures its guarantees of individual rights. And the court engages in this kind of structural argument, all the time. They did it in the Prince case, and whenever they find federalism type guarantees, they always say it's not really the 10th Amendment. The 10th Amendment doesn't speak about this. We're just kind of inferring it from the structure of the government of the Constitution. And so if you can infer things about states' rights from the structure of that the Constitution lays out, why can't you infer also what is left to individuals from the individual rights provisions of the Constitution? So, and the other thing that's interesting, and that I think I have to again attribute this to Mark, is this the fact that so the originalist folks don't know what to do with Griswold, right? And so because it doesn't fall into their history and tradition way of arguing about how you find a fundamental right, but they don't want to say that there's no right to contraception, right? And so Mississippi basically says in its Dobbs brief that Griswold is a Fourth Amendment case, which is just silly. It's about you can't invade the home, and rereads it, or is maybe being just narrowly about marriage as well, and that like the irony here is what an atextual understanding of Griswold that is, right? And it just kind of makes up its own interpretation of Griswold. So yeah, I think, but one other point about this kind of structural argument is this is something else that I think can be deployed and has been deployed in some state court cases, and actually in our Ohio case challenging the 6-week ban here. Ohio constitutional law actually says somewhat explicitly that you read the Constitution holistically and you read the different provisions as supporting each other. And so we have a healthcare privacy provision in our Constitution that is, or healthcare freedom provision in our Constitution that it was an anti-Obamacare kind of symbolic amendment, but we've used that to say, you should read this provision sort of together with these other provisions in the Constitution, equality, due process, to arrive at this right to abortion. And so far it's working, but we'll see. But I don't know, Mark, did you want to add anything to the Griswold stuff?
Yeah, just a team. Thanks, Jesse. So I guess I just want to put on the table not only the point that to re-up the point that Jesse was making about how Mississippi's lawyers were arguing to preserve Griswold, but also to underscore what I think is the significance of footnote 22 in Dobbs, which on some level purports simply to be rejecting the idea that there's any possible privileges or immunities clause founding for a right to abortion, but that in its operation begins to sketch out a theory that Justice Thomas has been advancing in a number of cases over time for a new set of rights protected under the privileges or immunities clause, which may entail not only the kind of economic liberties now broadly associated with Lochner, but defended on some originalistic counts and defensible in terms of what the privileges or immunities clause, not the due process clause, meant, as well as a set of substantive, what I guess I would call social rights that may include a new kind of traditional family values, family law that can sort of flower from the seeds that this footnote plants. So the rights are coming, but they may not be at all the kind of rights that we're talking about. I guess I'll just say like the tiny little bit of hope is that there are possibilities of transvaluing a new privileges or immunities clause jurisprudence in just the ways that led Justice Scalia to sort of dismiss the possibility of overturning slaughterhouse cases and bringing privileges and immunities back as a darling of the professoriate, meaning not something that he liked.
I just want to mention, question, what do judges actually do? And I've worked for years on some I've never published, to determine how they articulate what their duty is. And the different versions of it that I found were fealty to self, like I cast everything else aside. So I guess I'm a little being realist because it seems to me like there's not much casting aside your discourse and stuff. But there's several other. One is as a guardian of liberties. We're here as a guardian. And so in a lot of ways, except I guess when originalism invaded, they began to be self-conscious about it. There are about 7 ways they articulate what their duty is as a judge, one of which is command. I have to decide. So when they get a case and like, why are you going to decide this? They say it's my duty. But at any rate, so I think that there's a pervasive idea of judges that's not quite as intellectualized as some of what we're hearing here. And they have these conceptions of duty, which of course they point in different ways. The Justice Sutherland said he had a duty to engage in legal discourse, therefore he had to write dissents. Which of course opens up the point that a law is not fixed and we're in a discourse of dialogue. And originalism is sort of trying to foreclose that. And so I'm not sure how much inside the court, except now there's been politicized, these notions about interpretation holds sway. It's generally been conceptions of what is my duty as a judge. And where those, each one of them leads is hard to say. So they're not that intellectual, actually.
Jonathan.
Okay, I want to come back to the claim that Dobbs is an originalist decision. A lot of people have raised questions about that, but I think we can see the difficulties with that claim if we look at a second really important decision from last term, the Bruin case, the Second Amendment case. Because in Dobbs, we see the majority going back to the 1300s or maybe the 13th century and stopping essentially in 1868 and saying, therefore, there is no basis in any understanding of originalism for an abortion right. And then we look at Bruin, which is decided within a few days, in which the court says, as a matter of the original understanding, aside from the casting out of means ends analysis, which goes back at least to McCulloch against Maryland, that's all, we can talk about that another time. The only original understanding that matters is in 2 years, right? 1791 and 1868. And all the stuff before and all the stuff in between, and even some stuff that was a little bit later, doesn't count, right? So we can say, as an intellectual matter, that if there is a justification for originalism, Dobbs and Bruin are at least as bad in defense of that position as Roe or Griswold may have been. And I agree with Jesse that there's a lot more to be said in favor of those decisions, right? But even if you accept that there might, that the critique of those, it seems to me that the case for originalism has not been helped in any intellectual sense by what the court did last year. But now, if we step back from our law professor's role and think about this in terms of what do lawyers do, and even what do we as legal scholars say going forward? Just as Charles Houston and Thurgood Marshall could not have gone into court in the 1930s and said, Plessy against Ferguson was a legal and moral outrage, and you should ignore it. Right? They'd been laughed out of court. We can't really say that originalism is bunk and is basically a rationalization for other things. So this, I apologize for the length of the question, but the punchline is, where do we go from here as lawyers? What kinds of arguments are available? And maybe in some respects, there are limits, but especially if we're litigating some of these issues in state courts, what kinds of arguments might have some legs, even in the face of what the US Supreme Court has been doing? By the legislature.
Yeah, I mean, I don't, it's like, it's a big question, it's kind of a big question right now, right? And I think, I don't know, I wish I knew, I think that one possibility is whether, advocates should be presenting sort of counter histories, to dispute the history that seems to just be presented as objective and as pointing in one direction. And, there's plenty of room to do that, right? Like, I mean, I think even, in the abortion context, there's plenty of room to dispute the historical account of abortion regulation in America. So, but I don't, but you're not probably going to win with that, right? You might be building like a bunch of dissents. And then the question is, are you then buying into this originalist project in a way that is ultimately going to be damaging? Or, it's already, I mean, we were talking about with Bruin, courts are famously throwing up their hands trying to apply Bruin. They have no idea. They're hiring historians, right, to come give expert testimony on history. And so I'm not sure that's the direction we want to go in. Yeah, I don't know.
This is a very small offering, but I think Roe, I love your defense of Roe, Jesse. I couldn't agree more. And I think the Roe bashing of like, oh, so sorry.
I appreciate your defense of Roe so much. And I definitely felt like as a law student of the 90s of being like, this is just the first lady constitutional, right? And all the male law professors don't like it. I mean, that was my interpretation of those articles as a student, was like, oh, it's a lady right. But I feel like Roe doesn't give it enough credit for its originalist passages and its analysis of the 16 places in the Constitution that use the word person, and how the framers couldn't possibly have been thinking of embryos and fetuses because it doesn't make any sense to supply that. And so the idea that the framers weren't, of course, thinking about embryos and fetuses as people to be protected as an originalist argument. And then where do you do with that? Is that then a matter for the legislature, or is that a zone of privacy that is protected, is still an open question. But to me, if we can claim, and I know this could be debated in circles, that women are 100% people protected by the Constitution, that the Constitution would not allow the prioritization of a non-person over a person's interest. And that is between the lines, to me, what Roe says, that when the passage where the court says, when, theologians, scientists, blah, 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 cannot establish the nature of an embryo or a fetus, that is beyond the judiciary's capacity at this time. What they're saying is we have this metaphysical mystery, and then we have actual persons under the Constitution, and that the framers and any kind of interpretive lens couldn't have meant to allow that flip of priority. So for me, I think there's an originalist argument that direction. Yeah, I'll stop there.
No, I was just going to say that's a great point, and also a textualist, right? And an intra-textualist argument as well, yeah. What were you
Well, I
doing?
just wanted to mention that I was looking recently at a book that I read a while back by H. Jefferson Powell. So knowing his name, I hate to say, tell us a little bit where he is, but it's called The Moral Tradition of American Constitutionalism, a Theological Interpretation. And it turns out it's considered to be Christian stuff. And I read it because I like the idea of around. I didn't quite notice how much Christian he said he was, but he cited what you just said, about it's beyond the capacity, and he said, that means the courts can't do it and the legislatures have to do it. Well, we've seen what the legislature's doing, you see a lot of deep moral reasoning, I don't. Perhaps Mark would say, well, they're doing their kind, but you know, the death penalty for having an abortion.
That was a freedom of conscience decision, that the moral reasoning will be with the individual.
Right,
Right.
but the moral reasoning, in other words, I had respect for it way back when I read it, and when I just read it, I thought, ha ha. The idea that the courts confessed a lack of competence, therefore the legislature is the place where we can do good moral reason.
So I guess I'll just jump in and add a point about the new opinion. And then sort of how it points back to Dobbs. I mean, part of what's striking about the new opinion's paternalistic stance, not novel, is how it exceeds the context of abortion decisions and any reproductive choices, which to me anyway, as I read it, struck me as raising a question about the future of constitutional protections for women's equality, either under the Equal Protection Clause or sort of as a matter of liberty. And you know, one of the striking features both about Dobbs's brief engagement with the equal protection arguments, and then an argument much later in the opinion where Justice Alito is trying to reassure those who are concerned about sending abortion rights back to politics. And he says, don't worry. Women are a political majority who can take care of themselves. Is that Dobbs aligns itself with the position that Justice Scalia took in his VMI dissent and generates an argument for dismantling constitutional sex equality protections across the board. So you know, sort of the lady right or the rights of ladies in a wider sense are directly implicated, and the court has already poured the foundation for either cutting back or eliminating constitutional protections for sex equality in a wide sense.
In every lecture I've given on this, I've talked about women's personhood is actually what's attacked in Dobbs. That's about women's personhood, not the implication of embryonic and fetal personhood. My rights got downgraded for sure. My lady rights.
Going in the corner.
Getting your steps in.
Absolutely.
Thank you very much. My question is primarily for Mark, but I'll take anyone's opinion on this. I think it's a very interesting perspective. I appreciated, Mark, your analysis on the Texas Mifepristone decision. I hope I'm pronouncing that right. And how it was kind of the legal carriage before the narrative horse, and how it might have to be sacrificed even if it was going in the direction the court wanted it to eventually go in. But I'm interested in another aspect in which the legal carriage might get in front of the narrative horse, and that is applying state level religious freedom restoration acts as a method of protection for abortion rights. And given your apparent familiarity with the religious tethering in the law to these particular issues and how a certain narrative is being pulled, how do you think that RFRAs, which were passed on the state level, typically by conservative Christians to maintain a conservative Christian minoritarianism, would continue to, I guess, bite back at them and protect a right to reproductive health on a state level? And as a follow-up to that, how do we get around the fact that now they've wisened up and have added specific provisions saying, okay, you have this, but you can't apply it to this abortion statute and this abortion statute and this abortion statute? How do you think that holds water?
Thanks for the question. I think at least part of the answer goes back to something that I was understanding Katie to be saying. You know, Dobbs is not the first case to really, I think, ground the abortion right in a deeply spiritual vision. I'm not I'm not entirely sure whether the conceptualization of the right in Roe as a matter of conscience sort of resonates in spiritual or religious directions. I think it's something I'm interested to talk about, Katie, and with others. But certainly Justice Kennedy's opinion in Casey is a deeply spiritual opinion. I mean, the part of the joint opinion that's widely attributed to Justice Kennedy. And here, I guess the vision is one of real religious and spiritual pluralism. And I think that the sort of the part of the way to resist what Dobbs is up to is to really serve that part of Casey back up and re-inject it into dialogues. And then what we really have is at least two kinds of approaches to understanding religious liberty. One that's sort of broadly pluralistic and another that's more sectarian. And I think that those different visions can drive how one interprets RIPA's sort of at any level of government. I do think, though, in order to open up that space, those who are sort of generally on the left progressive side of the whatever political spectrum have to start sort of recognizing and coming to terms with many of the ways in which the project of left liberal progressive politics isn't only grounded in secular reason, but is for many people part of a long-standing practice of spiritual and religious practice. And I don't think we have fully done that, or even really started to do that on a massive scale on the left. But I think that part of what's happening is a response to a felt sort of broad sense of lack of meaning, and spiritual awakening is clearly happening sort of on the political right. And for me, part of what's interesting to bear witness to and to try to see sort of how it unfolds is what kinds of spiritual awakenings may happen in part through reproductive justice movements and other movements deeply committed to a broad intersectional vision of liberty and equality and freedom, what they bring in their wake and how the courts respond to them. That answers.
If I could just like add on the sort of more narrowly doctrinal piece, I just want to flag that doctrinal / political question, I guess, that there's an article, a number of people have been writing kind of about this set of like religious freedom questions in relation to abortion. There's an article I think out soon by Micah Schwartzman and Rich Schrager at UVA talking about how like because the Supreme Court's religious freedom and free exercise clause jurisprudence has sort of expanded so much in the past few years, that really just like as a doctrinal matter, it seems absolutely clear that abortion bans are unconstitutional under the free exercise clause for the most part, and at least as applied to many, that many people have valid challenges to them, and that there is no way, right, that there's no way the U.S. Supreme Court is going there anytime soon, and so it does raise absolutely this question of like, what does that mean, and where, like, what is it? Are they going to bend their free exercise jurisprudence, and distort it because of this, or is something else going to happen? And and what does it mean that we kind of know, like everybody's nodding that we know that going in, right? And it's so anyway, it's a really interesting, important question.
Do we have any other questions in the audience?
Oh, I will ask. So, how are the state challenges going based on state constitutions, Jesse? I know you've had some success here in Ohio. What's the landscape like?
Well, that's a good question. I mean, I think so far, actually better than expected. So, there have been a lot of decisions in states where there were expected to be losses, like South Carolina. We don't know, like Indiana is still up in the air, but potentially Indiana, Wyoming, where these bans have been enjoined on state constitutional theories, where folks did not necessarily go in thinking that the state courts were going to be friendly to these challenges, and so again, I'm not quite sure what to make of that. I'm not sure where it's all gonna shake out in the end. I mean, clearly it's a temporary answer. I don't think it's gonna, it's not gonna work everywhere, right? And even if you get a good state Supreme Court ruling, right, there's gonna be more political action, there's gonna be, justice is impeached, there's gonna be, attempts at constitutional amendments, and so, I don't know where it's all gonna end or how promising a strategy it is in the long term. I think it's like a short-term, attempt to hold on to access while everybody's trying to figure out what comes next.
Yeah. I don't know if other folks have reads on that who've been following it.
How about the state referendum initiatives? Because I know we have one going on here in Ohio, but the legislature is trying to make that impossible by raising the percentage that you need. Is the same happening in other states as well?
Actually, yeah, and we are seeing other states where there have been efforts to both put, where it's possible to put reproductive freedom on the ballot, and then also legislators trying to tinker with the threshold for passing a state constitutional amendment by the initiative process. And so, I guess again, it's just like this, there's this endless sort of like political vicious circle where I don't know what the last word is going to be. Like it's really hard, and I think again that's part of why I thought wanted to sort of hear people's thinking about this, because it's really hard to see what the future looks like right now. It's hard to see, as you were saying, like even into the next few months, what rights and justice is like in the US, but where is that? Like what is the end?
Actually, I saw that one state is planning to keep referendum as carve out abortion as something that can't be.
Yeah.
Got a question down here.
Thanks. Thank you all. I feel like this has been a really interesting discussion. Mark, I was really just fascinated by your talk and just thinking about, the ways in which the right is sort of seeding these natural law arguments, right? And using terms like unborn human, right? And, the long-term goal, I think, is really to recognize fetal personhood, right? And the constitutional protections probably for fetuses. And I mean, I feel like there's no textual support, and sort of there's not, as you were saying earlier, there's no originalist argument for that. So like, how do you think, the conservatives are going to sort of reconcile these natural law claims, right, given their sort of judicial philosophy? And the other thing that I'm really interested in is the ways in which sort of natural law arguments, which often are associated with human rights, right, are being sort of contorted to be viewed as sort of these conservative Christian interpretations, as opposed to interpretations under international human rights law. So I'm also just sort of curious about, like, if there are arguments that, ways to challenge sort of these natural rights arguments and human rights arguments.
Thanks, Cynthia. So I guess the real candid answer is I'm not sure how one goes about translating a worldview into any particular set of rulings. I think sort of the new decision out of the new district court decision out of Texas suggests the generative capacities of the conservative legal mind to bend doctrine in what would ordinarily be thought of as Overton window shifting kinds of ways. That said, I think, gin up a kind of claim about a right to life, and then you look at the text and, if you want to park it under the due process clause, I think that there are different ways that one can go about doing it. I guess, sort of your question and one of Jesse's last remarks really just sort of makes me think, we regularly teach law as sort of the text of the case, and doctrine is grounded there, or in the text of the statute. And part of what's, sort of happening is, sort of, we know what the real law, the tougher, to quote Frankfurter, the tougher and truer law, sort of the law as the court is articulating it is. And I mean, this goes back to Jonathan's question, I think, in a different kind of way, from a different kind of angle. Sort of that as people, as students of law, as teachers of law, we might be doing more to be engaging sort of with those underlying realities and trying to surface them and to find the ways to see them sort of bubbling up and operating in the text in ways that sort of just quick initial readings don't fully reveal. It's there, but it's how do you explain it? Where is it bubbling up? Because the justices and judges are aware of the rule of law norms as they exist now and are working overtime in some ways to preserve their fidelity to them and the claims and the claim making and the forms of reasoning, even as the opinions sort of have these energies that are just inconsistent with starting with the rule of law and starting from this other position. So as we sort of recognize the contouring and landscaping of certain conservative faithful worldviews behind the law, and it's like, how do we teach and how do we talk about that in ways that sort of are as best we can be truthful, and also in court recognizing that judges are actually aware of what the real law is. I mean, anyway, I think that probably connects.
It actually also just relates to when you were talking earlier about Idaho law, right? Because it's called abortion trafficking. And the people who have done work in the area of trafficking, this is clearly not trafficking, right? So it's really trying to conjure up the stigma and sort of negative attitudes towards trafficking in an area where that's clearly not at all relevant, right?
Thinking about how the judges can see their duty, there's Thomas that said, I made an oath to God, and that explains my duty. Now, that could just mean my oath to God is to do secular law the way it's supposed to, but I can't believe that's exactly what he's saying. So, that's right out there, that it's an oath to God as a judge. What follows? Let me see that.
Thank you. So my question, I guess, so the short version of my question, I guess, is directed for the panel, but Jesse, your remarks kind of brought it to the fore, is what is the role of critique, right? So, I literally rolled my eyes in the back of my head, made it hard for me to read the Dobbs opinion because my eyes were in the bottom of my head. As Alito cited all of these cis white men who had critiqued, Roe. But I take it as like my literal job to critique decisions, like as a critical thinker, right? I critique. And so even decisions that I, like from a policy outcome, Obergefell, Lawrence versus Texas, like it's my job to critique it because critique improves, right? It's sort of like critique uncovers the assumptions beneath the outcomes. Critique in my sort of orientation to the production of knowledge, critique actually leads to better outcomes. So as a person who liked the outcome in Obergefell, who liked the outcome in Roe, who liked the outcome in Lawrence, and so on and so forth, I don't think that I should abandon my critical orientation simply because there will be folks who will weaponize my critique and use it as an argument for different policy outcomes. And I even, when you were talking, and I've been thinking in the sort of dialogue after the panel, even, going to Kennedy's race, this is just Kennedy popped into mind, but Kennedy's race opinions and parents involved in community schools in his argument against the use of race consciousness in order to achieve some sort of level of racial equalization in schools. He's like, what is race? Do we even know what race is, right? Like race is a social construction, right? And that's exactly what critical theorists of race have been saying, for the past 50 years, if not more. So I guess my question is, is there a way that we should be thinking about our work as critical thinkers? Should we be aware that our arguments will be weaponized against us? I mean, actually, in Kaczmarek's opinion, he cites to Greer Donnelly and David Cohen's and Rachel Ray Boucher's forthcoming article about, and the article wasn't at all about like, we need to keep, mifepristone because folks are going to be using it to terminate pregnancies in states that have criminalized it. Instead, but he uses their argument as he weaponizes their argument in order to lead to the conclusion that he wants, which is we should, revoke FDA approval of this 23-year-old Medicaid. Anyway, all of that to say, how should we be thinking about our jobs as scholars, as critical thinkers, when we know that it will be weaponized against us?
And all the responses have to take 2 minutes, so.
Yeah, I mean, right, I'd love to hear what others think. I mean, I think that's interesting because when I was kind of contemplating this paper that I presented, it really does feel like all of those criticisms of Roe were like it was a luxury to be able to criticize it, right? Because it was like safe and everybody knew like the progressives had won, right? And then we now like see I think the same thing going on with originalism, and all of a sudden the originalists are trying to fight with each other over Dobbs and over different forms of originalism, and yeah, it feels like a very scary time for critique, right? When it can be weaponized, and for me, I think it's particularly hard because I'm wearing both hats sometimes of advocate and academic, and navigating that line as well is difficult. So yeah, that's my non-answer to that question. Maybe I was just helpful thoughts.
Mine would only be an article by Michael Gore called Dobbs Double Cross Our Justice Alito Misused Pro-Choice Scholars Word. He goes through all those people she's mentioning and shows that it's complete distortion of what they're saying. John R. Ely actually ended up being pro-Casey, I believe. Mentioned Mark Tuchman. His whole point is that law is bullshit. In other words, he critiques everything. So saying he critiqued Roe v. Wade is just a distorted thing. So the point is, if you talk, it's going to be distorted.
Deep question. It's a really deep question. I think the moment, and it's not a new moment in many respects, is just calling us all to be sort of as on our toes as we can and as alert to the possibilities that are lurking around the corners in the dark wood that we're now inhabiting, and to try to wield the power of critique, the bigger visions of liberty and equality and justice and freedom in mind that regularly animate them. But those are all the challenges that, sort of the work that that you and others are doing are, sort of about and on and with, and the question is an important reminder. So thank you.
And with that, we're going to end this panel. So thank you for